We've been talking about having Zack Smith on the show all day. Looking forward to our conversation with him. He's here now. He's a legal fellow at Heritage. Zack, thanks for calling.
Of course. Thanks so much for having me on the show today, Ryan. I really appreciate it.
So this is a big day. I don't know how much the average American is going to pay attention to this ruling other than to know, I can still vote for Trump in Colorado. The news, of course, is the Supreme Court has ruled that Trump can stay on the Colorado ballot. But this is kind of a big deal, right?
No, it's absolutely a big deal. And I think it came out the right way, the way that many people suspected it would. You had a unanimous Supreme Court essentially saying that states did not have the authority under Section 3 of the 14th Amendment to disqualify a candidate for the presidency of the United States. And that makes sense not only from a legal perspective, but from a practical one as well. Otherwise, you would have chaos.
Zack, did it surprise you that it was a 9-0 decision?
No, it didn't surprise me. It was a 9-0 decision. I think many people suspected it would come out that way. I think the court viewed this as being very important to be unanimous or as close to it as possible. I was a little surprised at some of the strident language that the three liberal justices used in their concurring opinion. But look, I think the result in this case was very obvious that states cannot disqualify Donald Trump or anyone else running for federal office from their ballot.
Yeah, Zack, I was looking at that concurrent opinion of both the three liberal justices, Sonia Sotomayor, Kagan, and Ketanji Brown Jackson, and looking at what Amy Coney Barrett had to say. Can you explain what their opinions were saying that was different than the majority opinion?
Yeah, basically what they were saying is that the justices in the majority decided too much, that those justices went too far. They said basically all the court needed to decide was that Colorado and any other state couldn't kick Donald Trump off of the ballot. The majority opinion went a little bit further and said that the way the Constitution envisions someone being declared ineligible for engaging in insurrection is that Congress will pass a law and provide a mechanism for that to take place. Elena Kagan and the other justices who wrote that concurrence seem to indicate there may be some other mechanism where the federal government can make that determination. What that is or what that would look like, I don't really know. And at the end of the day, I think the concurrences were really much ado about nothing because, again, the result in this case was so clear from the get-go, at least to many who had watched it working its way up through the lower courts.
Zack Smith, legal fellow at Heritage. Yeah, I've been reading this too, and I just can't quite understand, and it sounds like you're saying the same thing, which is good to know, what the three liberal justices were saying, because it sounds like they were saying, well, we agree that he should be on the Colorado ballot, but we really don't know why. That's kind of the way it was coming across to me.
Right. Well, that's exactly right. And so, if the court decided on some supposedly narrower ground, again, I don't really know what that would look like. There were a lot of different arguments raised in this case. For instance, is the president an officer of the United States? Is the presidency an office of the United States? So that Section 3 of the 14th Amendment would apply. And a lot of the argument, if you listened to it or read any of the briefing, really got into a lot of historical minutia surrounding the different practices at the time the 14th Amendment was passed in the wake of the Civil War. There was a case called Griffin's case that was decided in the late 1860s. It was an opinion by Chief Justice Salmon Chase, where he was actually sitting as a lower federal court judge in kind of a unique procedural issue. A lot of dispute over whether that case should apply or not. And so all of this is kind of the background. But look, at the end of the day, both from a legal and a practical perspective, this decision makes sense. And, I'll say one other thing very quickly. The Supreme Court's decision in this case essentially prevented almost 14 million people from being unilaterally disenfranchised by the elected officials of their states, because that's essentially what would have happened if the decision of Colorado, Maine, and just recently Illinois had been allowed to stand.
Oh, man, we love Illinois. Illinois does a great job. Brad and I both live in Illinois, and so, man, we just think they're doing a bang-up job. Let me ask you this, Zack. This is a little bit of a hypothetical, but we were kind of kicking this idea around in the first segment when we were reporting on this decision. So with the majority opinion saying that Congress has to basically decide that somebody is guilty of insurrection to keep them off of a federal ballot. I'm correct at that far, right?
Right, correct. Yeah.
Okay. So if that is the precedent that's been set now by the Supreme Court, would it be hypothetically possible that in a future election, if you had a, let's say, fully Democrat Congress or fully Republican Congress, could they vote to keep a presidential candidate off of the ballot using this Supreme Court case?
Well, look, I'll put a little bit finer point on what you're saying is essentially what's important to realize is that the 14th Amendment, Section 3, it's not self-executing. Congress has to pass a law that allows the provisions of the 14th Amendment to be put into practice. And typically what that means is Congress establishes a law with certain legal procedural mechanisms in place. And so, for instance, in the wake of the Civil War, Congress passed a law where the U.S. attorney in a given district could bring in action in the local federal court to disqualify someone under Section 3 of the 14th Amendment if they believed that person had engaged in insurrection or rebellion. And with that, there was a defined procedure. There were protections, including due process protections, and things of that nature put in place as well. And so I think that's what the court's saying. The Congress doesn't necessarily have to vote case by case, person by person, though they could theoretically do that. But Congress would have to put in place at least some procedure that would allow for this type of determination to be made.
So, Zach, based on the ruling today from the Supreme Court, does that automatically mean that he is on the ballot in all 50 states? You mentioned Illinois and Maine, or does that have to be revisited by Maine and Illinois and they have to come to the right conclusion now?
Well, he should be on the ballot. You know, the Supreme Court kind of waited until the very last minute to issue this decision, considering, Colorado's primary is tomorrow, as well as the primary in many other states. But, one of the things I think that didn't get enough attention about this decision, which I thought was very interesting, was that the court said state officials could disqualify candidates from state office based on Section 3 of the 14th Amendment. There would have to be a mechanism provided in state law for that to happen. And so I'm curious to see whether you may see follow-up cases involving people who were, in some way involved in January 6th or some of the other, post-election litigation, whether you might see efforts in the future to bar those individuals from running for state office if they ever choose to do so.
Zach, Donald Trump came out and spoke about this at about 11:45 today. That's actually what I tried to play from some sound at the beginning of the segment, and it was just the wrong thing. But I was going to play some sound that he was talking about some of the other legal cases. I think we were all kind of expecting him to make a statement saying, hey, this is the right decision. Glad to see the Supreme Court go 9-0 here. That's great. But he talked a lot about his other cases, and one of the ones that he was a little bit somber about was the Jack Smith case. Can you kind of update us on what happened last week with the Supreme Court choosing to take that case up, what that means for that case?
Yeah, well, unfortunately, I didn't get to see Donald Trump's press conference. But look, the fact that the Supreme Court is willing to take this case, I think it's going to end up being a very important decision. Now, what they're going to do with it, I don't know. They've agreed to hear it on a very expedited basis, almost lightning speed by Supreme Court terms. And so I think we can expect the decision before the end of June. Now, what that means in terms of the timing for any potential trial, should Jack Smith's case against Donald Trump survive, I don't know. Certainly, Jack Smith wants to try to bring these cases to trial before the election. Donald Trump obviously wants them to take place after the election. But I would think regardless, it'll be very difficult to get these cases to trial and get a verdict reached before November. But we'll just have to wait and see.
Zach, last question for you, and this is really bringing it right down to the foundations here. What is Jack Smith trying to do? What is Jack Smith trying to accomplish that the Supreme Court may have delayed here? What's his goal?
Well, certainly, again, he wants to get these cases to trial and have a verdict reached before the November election. That's one of the reasons you saw a lot of the unique procedural wrangling he did. He actually tried to skip over the Court of Appeals in this case, asked the Supreme Court just to take it originally. They said, no, we're not going to do that. So it went back down to the Court of Appeals. And only after the Court of Appeals reached its decision did the Supreme Court agree to once again hear this case. But certainly Jack Smith, he wants to prosecute Donald Trump, and he wants to do it as quickly as possible likely in an effort to impact the upcoming election, which is very unfortunate, I think.
Zack Smith, legal fellow at Heritage Foundation and co-host of SCOTUS 101. So thank you so much for your time today and your expertise.
Of course. Thank you so much for having me on.